Hey, good afternoon, class. This is Professor McLaughlin. How's everybody doing today? Today we're going to talk about both torts and crimes, but before we get to that, I want to do a little house cleaning. As I indicated in my email to you yesterday, we've had some issues with Blackboard, and hopefully we're getting them resolved. And then in regard to the paper, I will post the information on the quarterly or the semester project probably sometime later this afternoon. So again, I apologize for the delay. Um, so with that being said, let's move into the first area that we're going to cover today, which is crimes. And I think we all know basically what crimes are. It's basically breaking the law. But to kind of narrow it down a little bit, what I like to say is that crime comes in many forms and the culprits can sometimes surprise us. And I'd like to give you a couple of quotes for the day. The first one is from Ben Jonson. He threatens many that have injured one. And he was an English dramatist. And then the second one is most of the evils of life arise from man's being unable to sit still in a room. And that comes from one of my favorite philosophers, Blaise Pascal. Not only was Pascal a great philosopher, he was also a great French mathematician, one of my favorites. And it's important to know when we start talking about criminal case, knowing the difference between a civil case and a criminal case. A civil law involves rights and liabilities that exist between private parties. If one person claims that another has caused her a civil injury, she must file a lawsuit and convince a court of her damages. Conduct falls under criminal law when society outlaws it. When a state legislature or Congress concludes that certain behavior threatens the population generally, it passes a statute forbidding the behavior. In regards to the burden of proof, in a civil case, the plaintiff must prove his or her case only by a preponderance, and I repeat, a preponderance of the evidence. But because the penalties for conviction in a criminal case are so very, very serious, the government must prove its case beyond a reasonable doubt. So you've got preponderance, civil, reasonable doubt in criminal. Also, another differentiation is the right to a jury. And a judge or a jury decides the facts of a case. A criminal defendant has a right to trial by a jury for any charge that can result in a sentence of, say, 6 months or longer. The defendant may demand a jury trial or may waive the right, in which case the judge will indeed be the fact finder. And then you have two different types of crimes. You have a felony and you have a misdemeanor. A felony is a serious crime for which a defendant can be sentenced to 1 year in prison. These include murder, robbery, rape, drug dealing, money laundering, wire fraud, embezzlement, and any other felonies. A misdemeanor is a less serious crime, often punishable by a year or less in county jail. Let's say certain crimes like public drunkenness, driving without a license, and simple possession of one marijuana cigarette are considered misdemeanors in most states. Also, in criminal law, you have what they call criminal procedure. And under the criminal law, it has to be a voluntary act. A defendant is not guilty of a crime if he or she was forced to commit it. In other words, she is not guilty if she acted under duress. Somebody forced her or forced him to do it. Another area of criminal law we talk about in this particular chapter is entrapment. And by that I mean that's when the government, let's say in the form of the police, induces the defendant to break the law. The prosecution must prove beyond a reasonable doubt that the defendant was predisposed to commit the crime. You also have conspiracy. And this is an area of law that not many people are very familiar with. But if the police discover a plot to commit a crime, they can arrest the defendants before any harm has been done. A defendant can be convicted of taking part in a conspiracy if one of these three things occur. One, a conspiracy existed. Two, the defendants knew about it. And three, some members of the conspiracy voluntarily took a step towards implementing it or moving the crime or the act or the criminal act forward. In regards to gathering evidence, a lot of this is covered in the Fourth Amendment. And the Fourth Amendment basically prohibits the government from making illegal searches and seizures of individuals, corporations, partnerships, and other organizations. The goal of the Fourth Amendment is to protect the individual from the powerful state. The other thing that's required in a criminal action is a warrant. As a general rule, the police must obtain a warrant before conducting a search. The warrant must specify with reasonable certainty the place to be searched and the items to be seized. In addition to a warrant, there has to be what we call probable cause. Let me repeat that, probable cause. The magistrate or the judge will issue a warrant only if there's probable cause. Probable cause means that based on all the information presented, it is likely that evidence of a crime will be found in the place to be searched. How about searches without a warrant? There are 7 circumstances under which police may search without a warrant. Number 1, the item or the product has to be in plain view. Cannot be hidden, cannot be under the seat, has to be on plain view. Number 2, on a stop and frisk. If you stop and you believe a police officer or a legal officer feels that there's been a crime committed or a danger, they have the right to stop and frisk you, which means search your pockets, make sure you're not carrying a concealed weapon or something that could hurt them. Next, you have emergencies. That means when a life's at risk, property's at risk or whatever, and you have to search quickly, let's say looking for a bomb or something like that, you don't need a warrant. Automobiles, same thing. If it's in plain sight or you're stopped for a violation, the automobile can be searched. Lawful arrest. If you're arrested lawfully, where the officer places you under arrest, reads your Miranda rights, he has the right to basically search you and your vehicle. Consent. A lot of times, particularly on the TV shows that involve police officers or law enforcement, they'll say, hey, is it okay if I search your car? And unfortunately, a lot of people go, yeah, sure, I don't care. Go ahead. When you do that, you're basically giving your consent. No warrants required. And also in an area where there's no expectation of privacy. And by that we mean out in a public place, a park, out in the open, in a parking lot. Warrants not necessary. And with the advent and explosion of technology, that's created new challenges for the courts in determining what is a reasonable expectation of privacy. And police police do need a warrant to do the following 4 things. Search the digital contents of your cell phone or personal computer. Intercept email or regular mail that is in transit. Let me back up, not regular mail, only email. Read private Facebook profiles and postings, and attach a GPS tracking device to your car. The police do not need a warrant for those activities. So be careful, don't let any GPSs be stuck on the bottom side of your vehicle. The police also don't need a warrant to perform a DNA test on anyone they have arrested for a serious crime. They don't need a warrant to find out whom you've emailed, find out what websites you have visited, search your online chat messages, check your online dating profiles, or read your Twitter posts. And in regards to gathering evidence and collecting evidence, the law has created, particularly the Supreme Court in the last 50 years, what they call the exclusionary rule. And under this rule, evidence obtained illegally or any information obtained as a result of this illegal behavior may not be used at trial. The judge will remove the evidence because it's a violation of the exclusionary rule. And the Supreme Court has created this rule as a judicial remedy to protect all citizens from potential police abuse. The theory is that if the police know in advance that illegally seized evidence cannot be used at trial, they will have no motive to obtain such evidence and will go about their investigations lawfully. Remember also that some technical mistakes might be quite invasive, such as the police breaking down a door at night, entering an apartment, strip searching all residents, tearing up the premises, and then realizing that no crimes have been committed and that they had acted on a worthless tip. And that actually happens a lot more frequently than what you would think or even anticipate. After the arrest, we have what we call an indictment. A grand jury, which is a group of ordinary citizens, determines whether there is probable cause that this defendant committed the crime with which he or she is charged. If the grand jury determines that there is probable cause, an indictment issues. An indictment is the government's formal charge that the defendant has committed a crime and must stand trial. Because the grand jury never hears the defendant's evidence, it is relatively easy to get indicted. In other words, for the prosecutors to obtain an indictment from a grand jury. After that, you have what we call an arraignment. At an arraignment, a clerk reads the formal charges of the indictment, and at that time, the defendant must enter a plea to the charges. At this stage, most defendants plead not guilty. You'll also see the employment of a plea bargain, or the prosecutor, maybe the defense attorney, will try to arrange some sort of plea bargaining or plea agreement. A plea bargain is an agreement between prosecution and the defense that the defendant will plead guilty to a reduced charge, and the prosecution will recommend to the judge a relatively lenient sentence. In the federal court system, about 97% of all prosecutions end up in a plea bargain. Such a high percentage has led to some concern that innocent people may be pleading guilty to avoid the risk of a tough mandatory sentence. A judge need not accept the bargain. He can say no, but he usually says yes. Once you've completed discovery, you go to trial, and then following a trial, there may or may not be an appeal. When there's no plea bargain, the case goes to trial, and the mechanics of a criminal trial and appeal are similar to those for a civil trial described in Chapter 6 on dispute resolution. They also have a law that's called double jeopardy, and the prohibition against double jeopardy means that a defendant may not or may only be prosecuted once for a particular criminal offense. The purpose is to prevent the government from destroying the lives of innocent people with repetitive prosecutions. And what this basically means is, if an individual goes to crime, let's say, or goes to trial for, let's say, a crime like armed robbery, they can only be tried once. If they're in a severe automobile accident and they're tried and they're found innocent, they can only be tried once. And that's because of the rule of double jeopardy. Let's see, moving on, let's talk a little bit about self-incrimination. And self-incrimination is covered by the Fifth Amendment. And the Fifth Amendment basically bars government from forcing any person to testify against himself. In other words, the police may not use mental or physical coercion to force a confession or any other information out of someone. And this was basically established after the rule of Miranda. And after the Miranda case, you have what's referred to as the Miranda rights, and that's what you always see on cop shows on TV, where they say you have the right to remain silent. And a lot of times they'll read it right off a little card because they have to be very careful about the warning. And under Miranda, the police cannot legally force a suspect to provide evidence against himself. But sometimes, under forceful interrogation, he might forget his constitutional rights. In the following landmark case, the Supreme Court established the requirement that police remind suspects of their rights, the very same ones that we have all heard so many times, as I said before, on television. And I won't go into the Miranda case. I'll let you go ahead and read that. But basically, there was nothing in the constitutional law about Miranda rights or warning somebody before a confession. This is basically law that was created during the Warren Court back in the 1960s. And it really had a dampening effect on the ability of the police to do their jobs. A lot of times after interrogation, they'd get a confession. But after Miranda, it's my feeling that the game kind of changed and the rights of the defendant superseded the rights of the plaintiff. And philosophically and spiritually, I have a problem with that. But go ahead and read Miranda and understand the ruling in Miranda. Basically, before someone's charged, they have to be given their rights or read their rights and know and understand them. And under Miranda, it made it very clear a criminal defendant has a right to a lawyer before being interrogated by the police. The Sixth Amendment, on the other hand, guarantees the right to a lawyer at all important stages of the criminal process. That means if you cannot afford a lawyer, the state will appoint a lawyer to represent you. And he will represent you free of charge for any defendant who can't afford it. So now that we have kind of moved through and we have a basic understanding of criminal law, the process of indictment, let's talk a little bit about crimes that hurt business. And in this day and age, you have to be extremely cognizant of the crimes that can be committed during or against business. The first one we'll talk about is larceny. And basically, larceny is the trespassory taking of personal property with the intent to steal. The critical thing here is the intent to steal. If you're moving a product from place A to place B just to get it out of the way, there's no specific intent there to steal. There has to exist specific intent. Another business crime that you hear about quite frequently is fraud, and that refers to a variety of crimes, all of which involve the deception of another person for the purpose of obtaining money or property. Types of fraud include wire and mail fraud, insurance fraud, internet fraud, auctions, identity theft, and what we call in technology phishing. Phishing. Arson is the malicious use of fire or explosives to damage or destroy real estate or personal property. After arson, you have embezzlement. What's embezzlement? That's the fraudulent conversion of property already in the defendant's possession. And then one of the newer crimes that's been created, particularly since the advent of the internet, is hacking. And hacking is the gaining of unauthorized access to a computer system. Hacking is a crime under the Federal Computer Fraud and Abuse Act of 1986. So you can see it's a relatively new law or a new crime, primarily due to the advent and the creation of the internet and what I call the advent of digital technology. And even as we speak today, courts are now in the process of figuring out how to interpret the CFAA. And they talk about a former employee clearly violated his company's policies, but he did not commit a crime, and they ask you to be the judge. And that's in United States versus Nosal, which I'll go ahead and allow you to read on your own time. Moving on, let's look at crimes committed by businesses. Contrary to popular belief, a corporation can be found guilty of a crime based on the conduct of any of its agents, who include anyone undertaking work on behalf of the corporation. An agent can be a corporate officer, an accountant, hired to audit a statement, a sales clerk, or almost any other person performing a job at the company's request. If an agent commits a criminal act within the scope of his employment with the intent to benefit, the corporation or the company is liable. This means that the agent himself must first be guilty. Another crime that can be committed by business is called making false statements. It is illegal to make false statements or engage in a cover-up during any type of dealings with the United States government. And trust me, that's something you never, ever, ever want to do. But in dealing with the government in any way, shape, or form, you have to be extremely cautious. The other one, and probably the most probably the most prominently used by the Justice Department is what they call a violation of the RICO statutes. And RICO is an acronym for Racketeer Influenced and Corrupt Organizations. It's one of the most powerful and controversial statutes ever written. Congress passed the law primarily to prevent gangsters from taking money they earned illegally and investing it in legitimate businesses. And the RICO law started to become prominent. I should say it was first engaged by Rudy Giuliani when he was worked for the Justice Department. In the 70s and 80s, he was trying to break up a lot of the La Cosa Nostra families, or the mafia, back east. And as most of you are aware, if you're not aware, I'll explain. A lot of mob money is laundered through various businesses and products. And so if they can't catch the mobsters for committing, certain violent crimes, they'll go after them under the RICO Act, which is, again, the Racketeer Influenced and Corrupt Organizations Act. Very, very effective act. And I'm a little bit surprised when I see the number of organizations today that launder money quite openly, quite publicly, that the Justice Department or the Attorney General doesn't come in and really crack down on them. So what does this mean in English? It's the RICO process, or prosecution process, is two-step. It's a process to prove that a person or an organization has violated the statute. And in order to determine if a company has violated the statute, the prosecutor has to show that the defendant committed 2 or more racketeering acts, which are any of a long list of specified crimes, such as embezzlement, arson, mail fraud, wire fraud, and so forth. Thus, if a gangster ordered a building torched in January and then burned a second building in October, that would be 2 racketeering acts. Let's say a stockbroker told 2 customers the Bronx Gold Mines was a promising stock when he or she knew that it was worth. Hey, good afternoon, class. This is Professor McLaughlin. How's everybody doing today?
Good afternoon, and welcome to week 2.
Today we're going to talk about
Business
both
358
crimes, but before we
Business
get to that,
law.
I want to do
And
a little
blessings to all.
housekeeping. As
In
I
the second
indicated in
week,
my email to you yesterday, we've had some issues.
You should have
with
reviewed
Blackboard.
Chapter 2
Hopefully, we're getting them resolved.
and analyzed
And then
ethics
in
in
regard to the
corporate
paper,
and
I will
social
post the
responsibility.
information on
That's
the
primarily the
quarterly
topic
or the semester
for this
project.
session. And to
Uh,
kind of give you a
probably
quick
sometime later
overview
this
of the
afternoon.
chapter,
So
what
again,
I'd like to do is start
I
out with what
apologize
I call
for the
quotes
delay.
of the day.
um,
And the first is from
so with
Milton
that being
Friedman.
said, let's
the
move
one and only
into
social responsibility of business is to increase its
the
profits.
first area that we're going to cover today.
Milton
which
Friedman was a
is
Nobel laureate in
crimes.
economics.
And
And then also,
I
the
think
second
we all
quote
know
I'd like to share is the business
basically
of
what crimes
business
are.
is
It's
serving
basically
society,
breaking the law.
not just making
But
money.
to kind of narrow it down
And
a
that
little
came
bit,
from the
what
Dayton
I like to
Hudson
say is that
company's
crime
corporate
comes in many
constitution.
forms, and the culprits can sometimes
Let's
surprise
talk about the
us.
theme of this chapter.
And I'd like to give you a couple of quotes for the day.
Ethical
First
behavior
one is
refers to
from
how
Ben
people
Johnson.
should behave.
He
An
threatens many
important
that
point
have
to remember is that
injured
while
one.
laws represent
And he was an
society's
English
view of basic
dramatist.
ethics rules,
And then the second
some laws
one
permit
is
behavior
most
that
of the
some
evils
feel
of
is
life
wrong
arise
and
from man's
criminalize
being
acts
unable to sit
that
still
some
in
feel
a
are
room.
right.
That comes from one of my
It
favorite
is also important for
philosophers,
you to examine
Blaise
ethical issues from a
Pascal.
variety of
Not
points
only
of
was
view
Pascal
and to develop
a great
what I call your own
philosopher,
life
he was also a
principles,
great
the
French
rules by which you
mathematician,
live your own
one of my
lives.
favorites.
You should always
And
try to
it's
remember
important
that
to know
every ethics
when we start
decision
talking
you
about
make
criminal case, knowing
shows
the
your
difference
actual life principles,
between a civil
even if
case
this
and a
doesn't
criminal
match
criminal case.
what you say.
A civil law involves rights and
Some of you
liabilities
may be
that
asking
exist between private parties.
What
If one person
principles
claims
should
that
we
another has
include
caused her
and what
a
personal
civil
rules
injury, she must
should
file
we
a
have?
lawsuit and convince a court of her
These
damages.
principles, in
Conduct
number one,
falls
starts
under
off with
criminal law,
lying,
and society
which you should never
outlaws it.
do. Stealing,
When a state legislature
obviously
or
you never do
Congress
that. It's a
concludes that
violation of
certain
one of the
behavior
commandments.
threatens the
Cheating,
population generally, it passes
and
a
applying the
statute forbidding
same
the
or
behavior.
different standards at home and at work.
In regards to the burden of proof,
How
in a
about your
civil
responsibility
case,
as a
the plaintiff must
bystander
prove
when you see
his or
other
her
people
case
doing
only
wrong?
by a
In that
preponderance.
particular
And I
situation,
repeat,
you
a
have to be
preponderance
very
of the
careful.
evidence.
It's not
But
worth
because the
losing your
penalties
life
for
by
conviction
intervening in a
criminal case
situation that could bring
are
death or
so
bodily
very,
harm.
very serious, the government must prove
First thing we
its
ask
case beyond
is,
a
what's
reasonable
the
doubt.
role of business in
So
society?
you've got preponderance, civil.
Well, there's two main beliefs
reasonable
about
doubt,
where corporate
and
managers'
criminal.
primary
Also,
responsibility
another,
resides.
differentiation is.
Some argue their
the right to a
responsibility
jury.
is to the shareholders,
And a
while
judge or
others
a
argue
jury
they should
decides the
consider
facts
all
of the
company
case. The criminal
stakeholders,
defendant has the right to
including,
trial
say,
by a jury
employees,
for any charge that could
customers,
result in
and
a
the rest of the
sentence
community.
of, say, 6
These
months or
beliefs
longer.
influence
The
the
defendant
actions
may
executives
demand a
take
jury trial
when
or
they
may waive the
encounter
right,
an
in which
ethical
case
dilemma.
the judge
And
will
I will
indeed
tell
be
you
the fact
that
finder.
when you move into
And then
the
you have
halls
two
of
different
management
types
and business,
of
those
crimes. You have
dilemmas
a
are going to
felony,
be hitting you
and you have a
every day,
misdemeanor.
every week, every
A felony
month.
is a serious
and
crime
every year.
for which a defendant can be sentenced to
These
1
beliefs
year in
influence
prison,
the actions executives
These
take
include
when they
murder,
encounter an
robbery,
ethical dilemma.
rape,
An ethical dilemma,
drug dealing,
profitable
money
choice
laundering,
is
wire
not
fraud,
always the most ethical one.
embezzlement,
The most ethical
and
one,
any other felony.
vice
A
versa, is not
misdemeanor
always the most
is a
profitable.
less serious crime, often
If an
punishable by a
executive's
year or
only
less in
concern is
county jail.
maximizing profits, they will
Let's
likely
say
find themselves
Certain
making
crimes like
unethical
public drunkenness,
choices. And all we have to
driving
do
without
today
a license,
is look at the news
and
either
simple possession
online
of
or on
one
television
marijuana
set.
cigarette are
And we
considered
see executives
misdemeanors
from
in most states.
Uber to other countries constantly
Also,
in
in
trouble
criminal law,
or
you
putting
have
their
what they call
company in
criminal
peril
procedure.
because they've made the wrong ethical decisions.
And
You might ask yourself, okay,
under the criminal law, it has to be
I
a
get the argument,
voluntary
but
act. A defendant
why be ethical?
is not
Well,
guilty of a crime.
The key issue is doing the right
he
thing
or
may
she
not
was
generate
forced
the
to commit.
greatest
In other
profits
words,
over the long run.
She is not guilty.
It will lead
if
to
she
the greatest
acted under
personal
duress.
and community
Somebody
satisfaction
forced her
and
and forced
fulfillment.
him to do it.
So
Another
you
area
ask
of criminal
yourself,
law we
what
talked
do you
about
need to
in
be
this
happy in
particular
life?
chapter is
And some of your
entrapment.
answers may be
And by that I mean that's when
money,
the government,
fortune,
let's say in
fame.
the form of the police, induces
Many
the
of you now
defendant to break
realize
the law.
that that's not the
Prosecution
road
must
to
prove
happiness.
beyond a reasonable doubt that the
I
defendant.
can tell you firsthand as
was
an entrepreneur,
predisposed to
someone
commit
who
the
has
crime.
built a number of companies, one a
You also
publicly
have
traded
conspiracy.
company,
And
that
this is an
money
area of law
does
that
not lead
not
to
many people are
happiness.
very familiar
If
with.
anything,
but if
the opposite
the police
occurs.
discover a plot,
And these are
to
choices
commit
you'll
crime,
have to make as you move
they
through
can
your
arrest the
career.
defendants before any harm has been done.
Along those lines,
A
is
defendant
money
can be
an
convicted
accurate
of
measure
taking
of
part in a
happiness?
conspiracy.
I don't
if
think it is.
one of
I've
these
known very,
three
very few
things
wealthy
occur.
people, and I've known a lot of them.
One,
that are truly
a
a lot of them end up
conspiracy
dying
existed.
alone. A very
Two,
lonely existence. All
the
the money in the
defendants
world,
knew
but no
about it.
friends, no
And
family,
three,
because they
some
burned
members of
those
the
bridges.
conspiracy voluntarily took a step
So you have to ask
towards
yourself, are you
implementing
willing
it
to make a
or
trade-off
moving
between
the
reducing your
crime
earnings
or
to
the
spend
act
more
or the
time with
criminal
your
act
friends and
forward?
family? Think about it for a second. What
in regards
trade-offs
to
did your
gathering
parents have?
evidence, a lot of this is covered
I think
in the
all of
Fourth
us, mine
Amendment. And the
included,
Fourth Amendment basically
Worked hard
prohibits
and
the
went the
government
extra
from making
distance to provide a
illegal
quality life, not
searches
only for
and
you, but for
seizures
myself as well.
of individuals, corporations, partnerships.
Let's use an example.
and
Let's
other
say if
organizations,
after
the
making
goal
a purchase at a
of the
local
Fourth Amendment is
drugstore,
to
you
protect
realize
the
that the
individual
cashier
from
forgot to
powerful
charge you
state.
for an item. Or suppose a waitress
The other
forgets
thing
to
that's
charge you for
required
the
in a
drink you
criminal
ordered
action
with
is
your
a
meal.
warrant. As a general rule, the
What do you
police
do?
must obtain a warrant.
It's useful to
warrant
begin an
before
ethics
conducting
discussion
the
with
search.
small
The
personal
warrant
issues
must
like this,
specify with reasonable
because they
certainty
seem more real than
place
the
to the
abstract
search of the
business
items to be
issues you'll
seized.
find in
In
a
addition to a
textbook.
warrant, there has to be what we
Virtually
call
everyone
probable
has
cause.
had an experience
Let me
such
repeat
as
that,
these.
probable cause.
Many of you have worked as
the
servers and
magistrate
waiters.
or the judge
You know
will
what it's
issue a
like.
warrant
How many of you
only
have,
if there's probable
has had to pay
cause.
for items you
Probable
forgot to
cause
charge the
means
customer?
that
In this
based
way, you
on
can
all the
see that your
information
decisions have an
presented, it is
impact on
likely
real people.
that evidence of a crime
I'll
will
give
be
you a
found
personal
in
experience.
the place to be searched.
Several years ago, when I was playing golf up in Orange County,
How about
I found
searches
a wallet
without a
on the
warrant?
fairway.
There are
And inside the
7
wallet was $700
circumstances under which
cash.
police
And my
may
first
search
impulse
without
was,
a warrant.
hey, I have to find the
Number
owner. It
one,
wasn't to,
the item
hey, I'll take
or the
the cash and
product
say I found
has to
the
be in
wallet.
plain view.
So one of the
Cannot be
things, I
hidden,
took it
cannot
back
be
to
under
the
the
starter
scene.
and
Has
I
to
said,
be on
listen,
plain
I
view.
found a wallet that has a
Number
significant
2,
amount of
on
money
a
in it.
stop and frisk.
And he said, well, give it
If
to
you
me.
stop
I
and-
said, no, I think I'll hang on to it.
You believe
If somebody comes in or
officer
calls you and says they
or a
have the
legal
wallet,
officer feels that
here's my
there's been a
phone
crime
number, and I
committed
wrote
or
it down. I said, have
danger,
them call me.
they have the right
And
to
what I
stop
was trying
and
to
frisk
protect
you,
was the
which
cash
means
assets
search your
in the
pockets,
wallet.
make sure you're
It's
not
not uncommon
carrying a concealed weapon or
for
something
people
that
who
could hurt
find
them.
wallets to remove the cash
Next,
and
you
then
have
return
emergencies.
the wallet to the owner.
That means when
I wasn't
life's
going to
at
allow
risk,
that to happen.
property's
And
at risk
indeed,
or whatever,
the next day I got a
and
phone
you
call
have to
from a
search
gentleman
quickly, let's say looking for a bomb
who
or
had
something
lost the
like
wallet.
that.
I asked him to
You
describe the
don't need
wallet
a
and how
warrant.
much cash was in it. He
Automobiles,
said $750.
same thing.
I
It's
said,
in
I
plain
got it.
sight, or you're
So then
caught
I ended up meeting
for
him
violation,
at a Denny's restaurant
the
to give him
automobile can
to
be
return the
searched.
wallet to him. And at that time, he took out a
Lawful
$100 bill
lawful
and offered
arrest.
it
If
to me.
you're
I said, no.
arrested lawfully,
You shouldn't be
the officer
compensated or paid for
places
doing
you
the
under
right thing.
arrest. Read
And
your
in
Miranda
that particular
rights.
situation,
He has the right
I
to
made the
basically
right
search you.
ethical decision.
And your vehicle. Consent. A lot
Also,
of times,
society as a whole benefits
particularly
from
on the
ethical
TV
behavior.
shows that involve police
I think
officers
mutual
and law
trust is a
enforcement
vital
will say,
part
"Hey, is it
of
okay
a
if I
successful
search your car?"
society.
And unfortunately,
And
a lot of people
no
go,
society
"Yeah,
will
sure, I don't
survive
care.
long
Go
if
ahead."
the people
When you
constantly
do
have
that,
to
you're
protect
basically
themselves
giving your
from
consent.
dishonesty
no
And
warrants
the government
required.
is compelled to
And
regulate
also
businesses
in an area where there's no
severely
expectation
to ensure
of privacy.
fairness.
By that we mean out in a public place, a park, out in the open.
John
in a
Akers,
parking lot.
the former chairman of
Warrants not
IBM,
necessary.
he put it this way.
And with the advent,
There's no
and,
escaping this fact. The greater
um,
the measure of mutual trust
explosion
and confidence
of
in
technology,
the ethics of society,
that's created new
the
challenges
greater
for the
its
courts in
economic
determining what is a reasonable
and
expectation.
if you look at our society
expectation of privacy,
and our economic
privacy.
strength,
And police
right now we
do not
basically
I'm sorry,
lead
let
the
me
world.
rephrase that. Police do,
But to continue
need a
doing
warrant
that
to
with the next
do the following
generation
four things:
of managers, owners,
search the
entrepreneurs,
digital content
we have to create
of
the
your cell
mindset
phone or
that
personal
there has to be
computer,
extremely strong
intercept
ethics.
email or regular mail that is in transit.
The other thing is,
I'm
I've
sorry,
discovered
let
over
me
the
back up,
years
not
that
regular
people
mail,
they feel
only
better when
email.
they act ethically.
Read private
And the
Facebook
reason is they don't
profiles
have
and
to worry
postings.
about looking over
and
their
attach a
shoulder and wondering if
GPS
somebody's
tracking
going to
device
finally
to your
catch
car.
up with them because of a lie
They do
told,
not. The police
or
do
maybe
not
some
need a
ethical
warrant
break they took
for
in their
those
life or in
activities.
their job or in their business.
So be careful. Don't
And the
let any
question you have to
GPS
ask
be
yourself
stuck
is,
on
what
the
kind of person
bottom
do you
side
want
of
to
your
be?
vehicle?
In what kind of world do you want to live? All business people must ask
The
themselves
police
these
also
questions
need a warrant to
when
perform a
facing
DNA test on
the
anyone they have
opportunities
arrested for a serious
to be
crime.
dishonest. I think
They don't
managers
need a
want to feel
warrant
good about
find out who
themselves
you've
and
emailed,
the decisions
find
they've
out what
made, and I think
websites
also
you
they want to
visited,
sleep well at night.
search your online chat messages,
The next thing is how
check your
costly
online dating
unethical
profiles,
behavior can
or
become.
read your Twitter posts.
And again, we've looked at recent
In
stories
regards
in
to
the
gathering
news, the Harvey
evidence and
Weinstein
collecting evidence,
fiasco and a bunch of
the
others,
law has created,
where you had men in powerful
the Supreme
positions
Court in
acting
the last
unethically and taking
50
advantage
years, what they
of
call
others
the
who weren't in powerful
exclusionary rule.
positions. As a result, they've lost
And under this rule, evidence
spouses,
obtained illegally
careers,
or any
everything
information
they own.
obtained as a result of this illegal
unethical behavior truly
may
can be
not
very costly.
be used at
And
trial.
it does not always damage
The
a
judge will
business, but it
remove
can
the
potentially
evidence
harm the
because
bad
it's a
actors in
violation
even entire
of the
industries
exclusionary
and even entire
rule.
countries.
And
We had a situation
the
back
Supreme Court has
several
created
years
this
ago
rule as a judicial remedy to
where
protect all
Volkswagen
citizens from potential police
adjusted or
abuse.
changed
The theory
the
is
readings
that if
on
police
the
know in
output of their
advance
diesel
that
engines.
illegally seized evidence
And there was a
cannot be used
horrific
at trial,
blowback.
they will have no
The
motive
CEO lost his
to
job. A couple
obtain
high
such
people
evidence and will
lost their
go
job,
about their
and they had to spend
investigations
billions and billions
lawfully.
of dollars in fines.
Remember also
That's a
that
situation,
some
an
technical
example,
mistakes
where unethical behavior
might be
was
quite
very, very
invasive,
costly.
such as the police breaking
So
down
the
a
question
door
is,
at
why
night,
take the
entering an
risk?
apartment, strip searching
What is the
all
cost of a
residents,
lost reputation? Well, I
tearing
always
up the
tell my
premises,
students
and then
the people I
realizing
mentor
that
is
no
the only
crimes
thing
have
you
been
have in
committed
business
and
is
that
your
they were acted
reputation.
on a worthless tip.
And once you
And that
destroy that
actually
reputation,
happens
you have
a lot
absolutely
more
nothing left.
frequently than what
And
you
most
would
of the
think or
time,
even
it's
anticipate.
pretty difficult, sometimes impossible, to restore
After
that
the
lost
arrest,
reputation.
we have what we call an indictment.
Unethical
A
behavior can
grand
cause
jury, which is a group
other
of
subtler
ordinary
damage.
citizens,
One survey showed that
determines
unethical
whether there's
behavior in the
probable
workplace
cause that this
has
defendant committed a
reduced
crime
productivity,
which
I'm
he
sorry,
or she
job
is
stability,
charged.
and profits.
If the grand jury determines
Unethical
that
behavior
there
in
is
an
probable
organization
cause,
also
an
creates
indictment issued.
a cynical,
An indictment
resentful,
is the government's
and
formal
unproductive
charge
workforce.
that the defendant has committed
Hey, we're
a crime
breaking the
and must
law.
stand
Why should I
trial.
care? Hey, we don't
Because
care
the grand
about
jury
customers.
never hears the
Let's do
defendant's
whatever we
evidence,
want.
it is relatively,
You can't afford to have that mindset.
easy to get indicted.
Although there's no guarantee
words,
that
the
ethical behavior
prosecutors
pays in the short or
to
long
obtain
run,
an
there is
indictment
evidence that
from
the
a grand
ethical
jury.
company is more likely to win financially. And if you look at the companies that have an extremely high level or standard of ethics, they're usually
After
in
that,
the
you have
Fortune
what we call
100
an
or
arraignment.
Fortune 500.
At an arraignment, a clerk reads the formal charges of the
I think
indictment.
ethical companies tend to have a
And
better
at that time, the
reputation,
defendant must
more
enter a
creative
plea to the
employees,
charges.
and higher returns
At
than
this
those
stage,
that
most
engage in
defendants
wrongdoing.
plead not guilty.
And we even see large companies like
They
Apple
also,
struggle
you'll also
with
see
the fact that they basically use
the,
slave labor
employment
overseas in
of,
China. Is that ethical?
a plea
Not at all.
bargain, or
Yet
the
Apple's perceived by
prosecutor,
many
maybe the
as
defense attorney,
social
will try to
do-gooders.
arrange some sort
And
of
I think
plea
they do a
bargain
lot of good.
or
But
plea
how
agreement.
ethical is it for
A
them
plea
to
bargain is
pound
an
on their
agreement
chest
between prosecution
and say,
and defense.
look at how ethical we
that
are
the
when they're
defendant will plead
employing
guilty
child
to a
labor
reduced charge.
in places like
And the
China and
prosecution
Malaysia.
will recommend to the judge a relatively
But if we decide we
lenient
want to
sentence.
behave ethically,
in the federal
we
court
have to
system,
ask
about
ourselves,
97% of all prosecutions,
or we have to know
end up in a
basically
plea
what
bargain.
ethical behavior
such a high
is.
percentage has
And
led
there are
to
several
some
theories on
concern that
ethics. We're making
innocent people
ethical
may be
decisions.
pleading
People
guilty
sometimes
to avoid
focus on the
the
reason
risk
for
of
the
a tough
decision.
mandatory sentence.
They want to do what's right.
A judge
If
need
they
not
think it's
accept
wrong to
the
lie,
bargain.
then they will tell the
He
truth.
can say no.
Other times people
But he
think about
usually
the
says
outcome of
yes.
their actions. They will do whatever it takes to achieve
Once
right
you've completed
result.
discovery, you
This his
go
choice
to trial,
between
and then
doing
following
right
the
and
trial, there
getting the
may or may
result
not be an appeal.
has been the subject
When there's no plea
of
bargain, the
much
case goes to
philosophical
trial,
debate over
and
the
the mechanics of a
centuries.
criminal trial and appeal are similar to those
One of
for
the first type of
described in
ethics
Chapter
we'll look
6
at is what
on
they
dispute
call
resolution.
utilitarian ethics. And
They
under
also have a law that's
utilitarian
called
ethics, the
double
correct
jeopardy.
decision is one that tended
And
to
the
maximize overall
I'm sorry,
happiness and
the
minimize
prohibition
overall
against
pain.
double jeopardy
Risk
means that
management and
defendant
cost
may
benefit
not or
analyses
may
are
only be
examples of
prosecuted
utilitarian business
for a
practices.
particular criminal offense.
But the critics of the
is to prevent the
utilitarian
government from
theory,
destroying the lives
or
of innocent people.
the utilitarian
with
line of thought, argue that it is
prosecutions. And
difficult
what this
to
basically
measure
means is
utility
if
accurately.
an
It's also
individual goes to crime,
it's a
let's
little
say,
difficult
or goes to trial
to predict
for, let's say, a
benefit
crime like
and harm
armed robbery.
accurately.
They can
I
only
agree
be
with
tried
that.
once. If they're in a severe automobile
Then you
accident,
have
they're tried and found
deontological
innocent,
ethics.
They can
That's a long
only
word.
be tried once.
Deontological.
And that's because
Proponents
of the rule
of
double
deontological
jeopardy.
ethics believe that utilitarians, they've got it all wrong, and that the results are not as important as the reason for which the decision is made.
Let's see, moving on
To a deontological
let's
thinker,
talk a little
the
bit about
ends
self-incrimination.
do not justify the means.
And
the
self-incrimination,
best-known proponent of
is covered by the
deontological,
Fifth
of the
Amendment.
deontological
and
model
the Fifth Amendment
was an
basically
18th
bars
century German
government
philosopher
from
and one of
forcing
my
any
favorites,
person
Immanuel
to
Kant.
testify against
He
himself.
believed in the categorical
In other words,
imperative.
the police
He
may
also
not use mental
thought that human
or
beings
physical
possess a
coercion to
unique
force a
dignity,
confession
and that no decision
or
that
any
treats people
other
as commodities
information out of
could be
someone.
considered just. The problem with this belief,
And this was basically
if that the
established
ends
after
do
the
matter.
rule of Miranda. And after the
the
case
third is
of
what
the
we call
Miranda case,
Rawlsian
you
justice,
have what's referred to as the Miranda rights, and that's what you always see on cop shows on TV where they say you have
the
the right to
circumstances
remain
people are
silent.
born
And
in
a lot
to
of
dramatically
times
affect
they'll
their
read it
outcomes.
right off a
That's
little
what
card because they have to be very careful
Rawlsian
about
justice
the warning.
is. American
under
philosopher
Miranda,
John
the
Rawls
police
referred to
cannot
these circumstances
legally
as life
force a
prospects.
suspect to provide evidence
In his
against
view,
himself.
luck matters as much as hard
Sometimes,
work.
under
And
forceful
coming from the
interrogation,
entrepreneurial world,
he might
luck
forget his
is critical to
constitutional
success.
rights.
You can work
In
and
the
work and
following
work, but you
landmark
have to have a
case,
little luck on
The
your
Supreme
side.
Court
I'm just saying that speaking from
established the requirement
experience.
that police remind suspects of
Moral
their rights.
universalism and
The very
relativism,
same ones that we've all
relativism
heard
is the next
so many
type of
times,
ethics.
as I've
Some
said
people believe
before,
that particular
on television.
acts are
And
always
I
right
won't
or
go into
always
the
wrong,
Miranda case.
regardless of
I'll
what
let you
others
go
may
ahead
think.
and read that.
And this
But basically,
approach is
there was nothing in the
called
constitutional
moral
law
universalism.
about Miranda rights.
Alternatively,
or warning
others
somebody
believe
for a
that
confession.
it is right to be tolerant
This is
of different
basically
viewpoints
law that
and
was
customs, and
created during
indeed,
the Warren Court.
a decision
back in
may
the
be acceptable
1960s.
even if it is not in keeping with one's
And it
own
really
ethical
had
standards.
a dampening effect on
This
the
approach is
ability of the
referred
police
to
do their
as
jobs.
moral
A lot of times
relativism.
after interrogation, they'd get a
So we've
confession.
talked about some
But
of
after
the
Miranda,
moral, ethical
it's my
approaches.
feeling that
What
the
are
game
some of the
kinda
traps you can
changed,
fall into?
and the rights of
Well, there's
the
a number of them.
defendant superseded the rights
Ethics
of the
traps
plaintiff.
create great temptation
And
to do what we know to
philosophically
be
and
wrong,
spiritually,
but
I
fail
have
to
a
do what we
problem
know
with
to be
that.
right.
But go ahead and read
here's a
Miranda
number of
and
traps we
understand
can
the
fall
rulings
into.
of Miranda.
And we've already
Basically,
talked about the
before
first one a
someone's
little
charged,
bit.
they
Money.
have to be
Is money the root of
given
all
the
evil?
rights or read the
Probably.
rights. And
I used to
no
say
one
no, it
understands
depends on the individual, it depends on the circumstances.
And under Miranda,
But after having a
it made it
long
very
life in the
clear,
corporate world, the
a
entrepreneurial
criminal
world, I would
defendant
have
has
to
a right
say,
to a lawyer before being interrogated
pretty close to
by the
absolute
police.
certainty that money
The
corrupts.
Sixth Amendment,
What about
on the other hand,
competition?
guarantees the right to a lawyer.
We're so
at
intent
all
on beating the
important
competition
stages
that maybe we're
of
willing
the
to bend a
criminal
few
process.
ethics, violate a few
That
ethics.
means if you
Don't do
cannot
that.
afford a
Even
lawyer,
if you're tempted,
the state
don't
will
do it.
appoint a lawyer to represent you.
And how many of us rationalize
And
our
he will
unethical
represent
behavior?
you free of charge.
Well, you know
for
what?
any
So-and-so from
defendant
company
who
B
can't
was doing
afford
it,
it.
so why shouldn't I do it? And that way we rationalize
So
that
now that we
what we're
have
doing
kind of moved through,
is
we have
okay.
a basic
In reality,
understanding of
by using that rationalization,
criminal
is
law,
what we're doing okay?
the process
No, it's
of
not.
indictment. Let's talk a little bit about crimes that hurt business. And in
How
this
about the
day
fact
and
that
age,
sometimes we can't be objective
you
about
have to be
ourselves?
extremely cognizant of
We're
the
more
crimes
subjective.
that can be committed during.
And we don't look at ourselves
or
from the outside and
business.
realize that
The first one we'll
what we're
talk
doing
about
is
is
wrong.
larceny, and basically
then we have conflicts of
larceny
interest. That's
is
one of
the
my
trespassory
favorites.
taking of personal property with
And
the
where you
intent
see the
to
most
steal.
conflicts
Critical
of
thing
interest,
here is
today
the
is
intent
in
to steal.
politics.
If you're moving a product from
Many of
place
our
A to place
politicians
B,
on both
just
sides
to
of the
get out
aisle
way,
Head off to
no
Congress with
specific
the best of
intent there
intentions,
to steal. There
and a
has
small
to
net
exist
worth.
specific intent.
And 4 to 8 years later, they come home and they're
Another
multi-millionaire.
business crime
People
that
in
you
their
hear
family
about quite frequently
taking
is
advantage
fraud.
of the
And that
benefit of
refers
some of the
to a
deals
variety of
that
crimes,
politicians have been exposed
all
to.
of which
I think
involve the
conflict of
deception
interest
another
is
person
probably
for
the
the
biggest trap.
purpose of
then
obtaining
conformity.
money or property.
Well, everybody else is doing it.
Types of fraud
so why shouldn't I
include
do it?
wire and mail fraud,
How about following orders? Hey,
insurance fraud,
not my fault.
internet
My
fraud,
boss told me to do it.
auctions.
How far will that get you,
identity
particularly particularly if
theft,
you're accused or
what we
guilty
call
of some
in,
criminal behavior.
technology
Not very
phishing.
far.
P-H-I-S-H-I-N-G.
And then euphemisms and reframing the problem.
Arson
Well,
is
that
the
really isn't
malicious use of
unethical.
fire
We're just
explosives
changing
to
this and
damage
this.
or
Don't
destroy
get sucked into that.
real estate or personal
How
property.
about using the excuse or the trap being lost in a
arson,
crowd.
you have embezzlement.
Well,
What's
you know, we were
embezzlement?
just one of many.
That's the
you know,
fraudulent
everybody
conversion
was
of
doing
property already.
it. Or
in the
perhaps you have a
defendant's
short-term
possession.
perspective. Well, we'll
And
do it
then
until
one
we
of
get
the
back
newer
on our
crimes
feet,
that's
or until we've
been
got a little bit of
created,
money in the
particularly
bank.
since the advent of the internet. Is
The other thing
hacking.
are the blind spots that can come
And
along.
hacking is the
Got to
gain
be
of
cautious of those.
unauthorized
Those are
access to a
ethic,
computer
what I
system.
call ethics traps.
Hacking is a
ethic
crime
trap.
under the Federal Computer Fraud.
So we've kind of
and
discussed some
Abuse
of the
Act
traps. How do you
1986.
avoid the ethical
So you
traps?
can see it's a relatively
Well,
new law.
3
a new
practices can
crime,
help you avoid these pitfalls.
primarily due to the
First of
advent
all,
and
what I tell
creation
people,
of the internet,
particularly
and what I call
the
advent
businesses
of
I
digital
consult with, or
technology.
even my students, is slow down.
And even as we speak
Life
today,
doesn't run at 78
courts are now
RPMs.
in the process of
Slow
figuring
down,
out
pause,
how to interpret
unclench,
the
take a deep breath,
CFAA.
and look at the problem.
And they talk about
The second one
a
is don't
former
always
employee
trust
clearly
your first
violated his
instinct.
company's policies, but he not.
And
he
I
did
beg
not
to differ a
commit
little
crime
bit with
when
the
they asked
authors
you
on this one.
to be the
I
judge,
slightly
and that's
disagree.
in United States.
I think your
versus
intuition
no
and your,
salt,
what I call your
which
gut
I'll go
instinct
ahead and
is
allow
very,
you to
very
read on
important.
your own time.
And if you think about it, how many times does your gut instinct say,
Moving on, let's
don't
look at
do this?
crimes
And
committed
you
by
go ahead and
businesses.
override it, and you do it anyway.
Contrary to
and you run
popular
into
belief,
trouble.
a corporation
I'm a very
can be
firm
found guilty
believer
of crime
of
based
listening
on
to
the
that inner voice
conduct of
when
any
all of a
its
sudden it sets
agents,
off alarm and
who
it says,
include
Peter,
anyone
maybe not, you
undertaking
shouldn't be
work
doing this.
on
You
behalf
shouldn't be doing
of the
this.
corporation.
And then the third
An
thing
agent
is
could be
remember your
a
life
corporate
principles.
officer,
And what I tell
An
students
accountant hired to audit
is
state audit
to remember the
statement,
golden rule, but I kind of
sales
refine it a
clerk,
little more.
or almost
What
any
I tell
other
them is,
person
what would your
performing a
mother
job
or
at the
whoever
company's
raised you, whether
request.
it was a grandparent, an aunt, an uncle, what would they say if they saw you doing this or knew you were doing
If
this?
an agent
And
commits
if
a
the
criminal
answer is
act
no, don't
within
do
the
it.
scope of his employment
Remember those life
with the
principles.
intent to benefit the corporation
So let's talk a little bit about
or the
lying.
company is liable. This means
We are
that
taught
the
from an
agent
early age that
himself
we must tell the
was
truth.
first
Yet
guilty.
research shows that we all tell between
Another
1 to 2
crime
lies
that can
a
be
day.
committed by business is
Shame on
called
us.
making false statements.
When is lying
It
acceptable?
is illegal
What about white lies
to
to
make
make other
false statements or engage
feel
in a
better?
cover-up
For example,
during
hey,
any type
I
of
really
dealings
liked your
with the United
lasagna,
States government.
but
And
the
trust
lasagna
me,
was horrible.
that's something you
Yeah,
never,
we all do
ever,
it. I'm
ever
guilty of it.
wanna
You tell
do.
little white lies so that
But
you
in
don't
dealing
hurt
with the
people's
government
feelings.
in any way, shape,
But
or
you've got to be
form, you have
cautious,
be
particularly about the
extremely
bigger lies,
cautious.
because if you lie and you
The
constantly
other one, and
lie,
probably the most
then you have to
uh,
remember each and every story you've told
probably
that
the
is a
most
lie,
prominently used
and eventually it'll come back to haunt you.
Department
If
is
you
what
tell
they
the
call
truth,
a
you have no
violation of
worries.
the RICO statutes.
Something comes up,
And RICO is
hey,
an
I told the truth.
acronym
This is what happened.
For racketeer influence.
What are your life
and
principles
corrupt
on lying? There
organizations.
may be indeed good
It's one of the
reasons
most
to lie.
powerful and controversial statutes ever written.
Obviously, to benefit other
Congress
people, to
passed
protect
the law
children who
primarily
say
to prevent
believe in Santa
gangsters from
Claus.
taking money they earned
It's useful to
illegally
analyze this
and
issue
investing it in
now
legitimate
than
businesses.
to try to rationalize it
And the
later.
RICO law started to become prominent. I
Having
should
thought
say it
about
was
the
first
ethics
engaged
principles and traps,
by
you now
Rudy
need to apply them
Giuliani
to
when he
situations
was
that are
the,
similar to those you're likely to face in your life.
worked for the Justice
And as I said
Department
earlier in the lecture,
in
there
the
will be
70s
many,
and
many
80s. He was
times
trying
in
to
life,
break up
whether it's
lot
a
of,
personal relationship
the
in business,
Costa Nostra
where you
families
have
or the mafia.
ethical decisions to
east.
make, and you have to rely on
And
your
as
ethical
most of you are aware, if you're not
principles.
aware, I'll explain. A lot of mob
Personal
money
ethics
is
in the
laundered through
workplace.
various
Should you
businesses
behave
and
in the
products.
workplace the way you do
And
at
so
home,
if
or
they
do you
can't
have a separate set of
catch the
ethics
mobster
for each
for
part of your life?
committing, certain violent
The
crimes,
answer
they'll
is
go
it
after them under
depends.
the RICO
You can do
Act,
things
which
in
is,
your
again,
home
the racketeer,
that are politically
influence, and
incorrect.
corrupt
You cannot do that in the
organizations Act.
workforce.
Very,
We've become
very
such a
effective
litigious
act.
society now.
And I'm a
You
little
have to
bit
be careful
surprised
with
when I see the
everything
number
you
of
do and
organizations
say.
today
You have to be careful
that
what you
launder
post
money
on your social
quite
media.
openly, quite
You can lose
publicly.
your management position or a
But
very
the
good
Justice
position.
Department or the Attorney
the
General
things
doesn't
people have
come in
found
and
on your
really
social
crack
media.
down on 'em.
So you have to be
So what does this
really
mean in
careful.
English?
I would
The
say
RICO
you
process,
have
the
a different set of
prosecution,
rules at work than you have at
prosecution
home.
process is two-step.
In my house, the
It's a
principles are
process
much
to prove that a
softer.
person or an
But
organization
when I'm
has
teaching at
violated
any one of the
the
classes
statute.
I'm teaching at the various
And
colleges,
in order to
very, very
determine
careful
if,
what I say,
a company
very
has
careful
violated
to make
the
sure I
statute,
framed it in the
the
proper
prosecutor
ethical
has to
framework.
show that the defendant committed
What if your
two or more
employees behave
racketeering
badly
acts
outside
which
of
are
work?
any of a
Should that
long
affect their
list
employment?
of specified
Absolutely.
crimes, such as
In this day and age, you can't afford to
embezzlement,
have an
arson,
employee who's a
mail
liability.
fraud,
And when I say a
wiretap
liability,
fraud,
you're doing
and so
something
forth.
really criminal.
Thus, if a
If they do
gangster
something
ordered a
really
building
stupid, you
torched
just
in
kinda laugh and
January,
say, "Hey, don't do that
then burned
anymore."
a second building in October,
But if
That
it's
would be
something that puts
the
your company's
racketeering
reputation reputation at risk or the possibility of loss.
Let's say a stockbroker told two
absolutely should affect their
customers
employment.
the Bronx
and you need to
Gold
get rid of
Mines
them sooner
was a
rather than
promising
later.
stock.
How about
when
the
he or she knew
organization
that it was
as a
worthless?
whole's
That would be considered
responsibility
two
to
racketeering
society? Many
acts.
products can potentially cause
So in
harm to
other words, the
customers and
prosecutor
employees.
must then show
What is a company's
that
responsibility
the defendant
to
used these
those who are
racketeering
injured by
acts to
their
accomplish
products?
one
It's
of
a good
three
question.
purposes.
I think we all know now that
three
companies have a
purposes we listed
social
above.
responsibility.
gangster
And you'll
committed
see a
two
lot of
arsons and
companies
then
give
used
away
the
a certain
insurance payments
percentage of their
to
income
say, to
to
purchase
various
let's say, a dry
charities
cleaning
or
business,
charities of their
that would
choice.
violate RICO. It's an attempt or an effort.
Now you ask, what are the
by that
organization's
criminal person
responsibilities to
launder
their
money. If the
employees? Well, it's
stockbroker
great.
gave
Unfortunately,
fraudulent
employees
advice
aren't treated as
and
well as
used
they
the
were
commissions
10, 15,
to
20
buy
years
advertising
ago.
for her firm,
And they've more or less
that
become
too
a
would
commodity.
violate
But
the
I've
RICO
found that the
statutes.
successful companies
Money
who
laundering
treat their
consists of
workers
taking
very
the
well, they
proceeds
pay
of
them a
certain
fair
criminal
wage,
acts and
good
are
benefits.
either using the money to
They
promote
don't lose a
crime or
lot of
attempting to
employees,
conceal
and they
the
have very
source
low
of money.
turnover.
And
But
in
sometimes
today's world,
looking
the
out for
biggest
employees
problem
may not lead to higher
that the drug
profits.
cartels
They cost you a
have
little
and
bit of
major
money.
crime syndicates.
In these cases,
is
doesn't an
getting rid of the
organization have a
money.
duty
as most of
to
you
take care
are
of its
aware of,
workers?
if a
I
certain
say
amount of money
absolutely.
is deposited into
Unless
accounts, particularly in cash,
some of these steps
if it's
will
over,
create
say,
to
$8,000 or $10,000,
basically the
it has to be
metaphysical destruction of the
reported to
company, then
IRS
you
and
don't
to the
do it.
government.
But to
So,
take care of
again, the
workers
biggest
and have them
difficulty these
loyal
criminal
and working hard for you,
institutions have is getting rid of
I think
all
the
their
company
cash.
has responsibility. And I think that's one reason today why so many companies blow through a number of employees and they have such a high turnover rate. If they'd spend more
Let's
time and
drop down to
capital
another,
investing on training their employees
kind of another
and
newer
showing them how to be
similar-
loyal and
similar to
effective,
RICO.
I don't
It's
think
called
you'd see
the Foreign
the
Corrupt
turnover rate that we
Practices
see
Act.
today.
And under this act, it
How
is
about an
illegal
organization's
for any
responsibility to
employee
its customers?
or
We talked a
agent
little
of a
earlier
US
about
company
Volkswagen,
and some
how they
foreign
basically
companies
hit
to give
emission numbers
anything of value
from all the
to any
people who
foreign
purchased their
official
cars.
for
And that blew up
purposes
in
of
their face. That was a
influencing
huge, huge
an official
problem.
decision, unless
Basically, your
the payment was merely
customers
intended to
are another
facilitate
group of essential
a routine
stakeholders, and a corporation
government action.
must gain and retain
And you will see
loyal
this a
buyers
lot
if
in
it
your
is to
business
stay
life
in
and your
business
business
for long.
career.
Even
where
a
certain
giant company
officials
like
are
Amazon,
bribed
they
with
all send you a
everything
questionnaire
from
after you
money,
purchase something.
jewels,
Were you happy with
vacations,
what you got? Was
to
the
expensive
service
and
good?
exotic cars.
And 9 times out of
Gotta
10,
be
you have to
very,
say
very
yeah.
careful when
Say
you're
yes to
doing
all of
business
that.
with.
And that's one reason why
foreign
Amazon
entities.
is
It's also
a huge
important that
company
you're
today.
careful not to accept gifts.
treating customers
on
well
other
usually
companies'
increases
behalf
profits, and
behalf
obviously
as
it
well.
helps all the
That's
shareholders.
something else that'll get you locked up.
But when, if ever, does an
fairly
organization go too far? Is a leader acting appropriately when she puts customers first?
How
in
is
the
a
way?
corporation
It
punished? The most
significantly
common
diminishes
punishment
the
for a
bottom line.
corporation is
The
a
shareholder
fine. This
model
makes
says
sense in that the purpose of a
do
business
you
is
say?
to earn a profit
Does the customer come
and a
first?
fine, theoretically,
Do you
paying out
become
a
so
lot of money.
absorbed with the
That hurts
customer
the
that it
business.
starts affecting
But
your
most
revenue,
fines are modest
maybe
by the
affecting
present
relationships?
standards of corporate wealth.
I don't think that's ever a good idea.
Sometimes they're not so modest. It can be up
How about
into
when the going
millions,
gets
and
tough?
even
How do you
billions
respond
of
to
dollars,
unethical
as we saw
behavior?
with the Volkswagen case.
Well, if you find yourself
when
working
they
for a
falsified
company
the
that
emissions
tolerates an
from their
intolerable
diesel
level
engines.
of unethical behavior,
The
you
the
face
federal
basically
sentencing
three
guidelines
choices.
are the detailed rules
You
that
have the
judges
loyalty
must follow
choice.
when sentencing
You have the choice
defendants
to
of
get the
crimes
heck
in
out of
federal
there, your
court.
exit choice.
The guidelines instruct judges
Or a
to
voice.
determine whether,
Let's look at
at
each
the
three
time of the
these,
crime,
equally.
the corporation had a
Loyalty.
place
Under
in-
loyalty, just because
had in
someone's
place
judgment
serious
is different from
compliance
yours
program. That
does
is
not
a
mean that they are
plan
behaving
to
unethically.
prevent
Being a team
and
player
detect
means
criminal
allowing other
conduct
people to make their own
at all
choices
levels of the
sometimes.
company.
However, the difference between being a team player and
So
starting
that's
down
kind of a
slippery
pretty good
slope can
overview
be very, very
of
narrow.
This particular chapter.
One of the big things in my life
this
is
was
loyalty.
chapter 6.
I expect
I
loyalty.
kind of
from my
switched it
family
around. I
and
wanted to
friends.
do
But that
my
loyalty,
chapter
I
6
only
before
expect it
8
to go so far.
because
If my
categorically in the
behavior
book,
becomes
chapter
unethical or
6,
illegal,
came
then I don't
first.
expect people to be loyal to me. And conversely, I'm not going to be loyal to them. Another
So
option
with
is to
that
walk
in
out the
mind,
door. You exit
let's
right out the
move
door.
Over
And you
to
do it quietly. You never make
chapter
a big
8.
scene.
And
This is
8
probably the
talks about
safest
negligence
for you because you're not
strict
ruffling any
liability,
feathers and you're not going to
and
make any
product
enemies.
liability.
And one of the things
So
you'll
we're
learn in
gonna cover
business is you never, ever,
mainly
ever
these
want
three
to burn
things in
bridges.
the lecture today.
You never
And
know. You
again,
may have
if
an
I
opportunity
mention a
down
case,
the road
make sure
to
you go
to
to
the
the
manager or
case in the
president will
textbook
want to hire you again.
and
So
you
don't
read
burn
and you thoroughly
bridges.
understand it.
But a quiet exit leaves
So,
the bad guys in a position to continue.
Let's
the
have a little
unsavory
overview
behavior.
of the chapter.
In short, the
basically
braver and better
theme
option
of this
may be to
particular
exit
chapter
loudly,
is when
reporting the
someone's
wrongdoing on the way
person
out
or
the door.
property is hurt. How far should
And an
society
example of that is all the
extend
whistleblowing that goes
liability?
on when
The law
employees
has
of companies see
struggled
over
for
a number of
centuries
years
to find
abuse,
compensation
abuse,
for the injured without
illegality,
making every
they become a
citizen
whistleblower, and
the
they're protected under
insurer
federal law.
of everybody
Some
else.
people choose that option,
And
but I have to warn you,
for
it's
this
a tough
particular
option.
chapter, I like
They run you through the ringer
quote
when
from
they
the
do
great
that.
Oliver
But sometimes
Wendell
it's hard to
Holmes,
do the right thing.
one
at
of the
the
greatest
ethical thing.
jurists
And
in the history
while
of the United States.
wrongdoing often
And
occurs
he made a
because
statement, the
everyone
life
just,
of the law has
goes
not been
along to get
logic,
along. Confrontation
Okay,
may
the
not
life
be
of the
the
law
only
has
or
not
even
been
the best
logic.
use of your voice.
It's been experience.
Learning to persuade,
He
cajole,
was
or
the
provide
Supreme
better
Court
options are
Justice.
all important leadership
And even more
skills.
importantly, I like
These are
what
skills you see in true leaders.
Thomas Jefferson said. I'm a huge
What about
Thomas
the corporate
Jefferson fan.
responsibility?
I think he's the greatest
Well, we know
statesman
companies have a
that
duty
ever
not
lived,
to
and
cause
without
harm,
Thomas Jefferson, we
and
would
you've
not have
had
the
famous
United
lawsuits
States.
against Monsanto.
And one of the things
Monsanto,
Jefferson said
other
was,
companies that
still
manufacture
one more thing,
asbestos,
fellow citizens,
that manufacture
a
particle
wise
board,
and frugal
and we
government
found out it was doing
which
harm
shall
to the
restrain
environment
men
and
from
people in
injuring
general.
one another,
So
and which
we
shall
we
leave
know that
them
they have a duty not to
otherwise
cause harm.
free to
But companies
regulate
have
their
a
own pursuits
corporate social responsibility,
of
that is an
industry
obligation
and improvement.
to contribute
And
positively
he
to
said
the
this at
world
his
around
first
them.
inaugural
Do
address.
businesses have an affirmative duty to do good?
That being said, let's
Harvard
start
professor
with probably
Michael
the
Porter
tort
has
that
written
most
that
of us are familiar
CSR,
with, negligence.
corporate social
And a
responsibility,
good question,
often
and a
benefits
question
company.
that
I
I
agree.
get asked pretty frequently. is,
However, in Porter's view,
what
a
is
company should
negligence?
not undertake a CSR project. In other words, don't get involved unless it is profitable for the
we
company
might
in
call
its own right,
negligence the unintentional
regardless of
tort
any
because
secondary
concerns
benefits the
harm
company
that
may
arises
receive
by
from,
accident.
say, an
Should a
improved
court, when
reputation.
this occurs,
So those are
impose
some of the
liability?
things
And probably the most
that you'll
famous
cover this
negligent
week in the book.
case
I look
of all
forward to
time
getting
is
your
the
first week
McDonald's
reports.
hot coffee
And I
case.
wish
think
you
everybody knows
a
about
blessed
that.
week, and I'll look forward
But I'll make an
to
exception, and I'll
seeing
kind of
you
review this case
and talking
quickly
to you
to give you an idea of
next
what
week.
happened.
So have a great day.
So you've probably heard of this case in which Stella, and I'm referring to my notes here, Liebeck sued McDonald's for burns she suffered after spilling a cup of its takeout coffee in her lap. It is also likely that whatever you students know about this case, it's either wrong or it's incomplete. You also may have seen a chain email about the Stella Awards named after Liebeck. Its message is that the tort system is out of control. Whatever problems exist with the tort system are not revealed by the stories in the Stella Awards email, because none of the stories are true. All are urban legends. They have been circulating online for years. But I will tell you this. When you buy a commercial coffee maker today, you will notice that the coffee does not come out as hot as it does in a Starbucks. The reason it doesn't is because of this particular case with McDonald's. I recently purchased a coffee brewer, and basically the coffee comes out lukewarm. A big part of it is because of the liability issues with the McDonald's case. As for Stella's suit against McDonald's, what most people don't realize is that the coffee that burned Liebeck was 180 degrees. That's 15 to 20 degrees hotter than coffee typically served in restaurants. The jury considered whether McDonald's acted improperly in selling 180 degree coffee. That was significantly hotter than a consumer would expect from common experience. All right, let's talk about that for a second. At the time, it was not uncommon to get coffee between 160 and 180 degrees. It was served very, very hot. But at the trial, testimony showed that before the lawsuit, McDonald's had received over 700 complaints about burns, some of them third degree, suffered by customers who spilled coffee on themselves. So right there, that tells us that McDonald's was put on notice that they were having an issue with people spilling coffee on themselves, and in some instances, suffering third-degree burns. A McDonald's executive testified that McDonald's knew of the risk of burns caused by its hotter-than-average coffee and knew that most customers didn't realize the specific risk posed by coffee at those temperatures, but nevertheless didn't intend to warn customers of the risk. The suit was about a mere failure to warn that coffee is hot. It was not about a failure to warn that coffee is hot. It was about a failure to warn of the danger created by serving materially hotter than normal coffee to customers who knew they were buying something hot, but not that hot. These facts, of course, cannot be construed only to support a finding that McDonald's was negligent. Discussing this case enables students to explore the concept of duty, due care, and the cost-benefit calculus involved in any business decision, and reinforces the important lesson that we should take time to learn the facts before passing judgment on anything. And here again, I once again respectfully disagree. Everybody knows that hot soup, hot coffee, hot tar that you tar a roof with is hot, and it'll damage you if it touches your skin. One of the things that bothered me about this case was that the plaintiff, after going through the drive-through, placed this cup of coffee between her legs in the seat. In my mind, that's an invitation, to disaster, or even an assumption of risk, which we'll talk about later in this chapter. Final note, I disagree with the finding in the case. That's my humble opinion, but read the case and let me know what you think. And when you talk about negligence, they talk about a duty of due care. And basically, you owe a duty to everybody in the world that you're not going to do anything, any actions that's going to place them in risk where they can become injured. And what the law says is we have a duty to behave as a reasonable person under the circumstances. Most court accept Justice Cardozo's viewpoint in the Palsgraf case. Judges drew an imaginary line around the defendant and say that she owes a duty to the people within the circle, but not to the people outside of the circle. The test is generally foreseeability. That's an important term, foreseeability. If the defendant could have foreseen injury to a particular person, she or he has a duty to him. And I'll let you go ahead and read Palsgraf and the Hernandez case, which will kind of give that some clarification. Again, what I'm going over here is kind of an overall view of duty, special duty, breach of duties, and that type of thing. But read the Palsgraf case and other cases to more or less familiarize yourself with it. What about special duties, and in particular, the duty of landowners? In most states, a landowner's duty of due care is to trespassers, okay? Often hire to children, especially if there is some man-made thing on the property that is likely to attract children. Hire still to a licensee anyone on the land for her own purposes, but with the owner's permission. And highest of all, to an invitee, somebody who's invited onto the property. And basically what this says is when you own land and somebody comes and visits your property, or you've got something on your property that's attractive that would make children jump over the fence or walk around the fence to get into your property, as a landowner, you owe those people a duty. How about professionals? What type of special duty do they owe? A person at work has a heightened duty of care. While on the job, he or she must act as a reasonable person in their particular profession. Let's talk a little bit about what constitutes a breach of duty. If a legal duty exists, if somebody's within that sphere of influence, then a plaintiff must show that the defendant did not meet it. Causation. To win, the plaintiff must show that the defendant's breach of duty caused the plaintiff's harm. Courts look at two separate causation issues. One was the defendant's behavior the factual cause of harm, and two, and more importantly, was it the proximate cause of harm. In a factual cause, if the defendant's breach led to the ultimate harm, that's the factual cause. The defendant did this, this, and this, ergo, we end up with this result here. The proximate cause is different. And under the proximate cause, for the defendant to be liable, the type of harm must have been reasonably foreseeable. In other words, it was foreseeable that this injury could occur or that this harm could occur. And one of the cases they cite there is Brunberg versus Cipriani, USA. Make sure you read over that and understand it. So let's say you claim negligence, you prove causation, an injury has occurred. What type of damages do we talk about? Well, the plaintiff has to prove that he or she has been injured or that he or she has had some kind of measurable losses. What qualifies as an injury is sometimes litigated. The plaintiff must persuade the court that he or she has suffered a harm that is genuine, not something that's speculative. It has to be genuine. So we've talked about damages, we've talked about risk. Let's talk about the defenses now. What are some of the defenses for a negligence cause of action? Well, number one, and I mentioned it briefly before with the woman who placed the cup of hot coffee between our legs. Whenever there's an obvious hazard, a special rule applies. Assumption of the risk. A person who voluntarily enters a situation, i.e. putting the cup between her legs, that is an obvious danger cannot complain if he or she is injured. And for the life of me, if I examine all things common sense, I cannot see where somebody, I don't want to say not in their right mind, but prudently would place a cup of scalding hot coffee between their legs while they're driving. The other defenses are contributory and comparative negligence. Here in California, we have comparative negligence. And what you should go over when you go through the damages here in this chapter, pay particular attention to these two defenses and the doctrine of contributory negligence and the impact of contributory negligence on the jury award. The final type of liability is what we call strict liability, and some activities are so naturally dangerous that the law places an especially high burden on anyone who engages in them. A corporation that produces, let's say, toxic waste can foresee dire consequences from its business that a stationery store cannot. This higher burden is strict liability. There are two main areas of business that incur strict liability. The first is what we call ultra-hazardous activities. And usually those activities include dynamite or explosion, or the release in the air of extremely toxic gases or fluids. Defective products are discussed later on in this chapter in the section of product liability. Let's talk a little bit about product liability. And in regards to negligence, negligence cases concerning goods, plaintiffs typically raise one or more of these claims. A, they'll say that the design of the product, of the automobile, of the piece of machinery, of the lawnmower, of the fan, the design was negligent in of itself. Number two, the product was manufactured negligently, wasn't manufactured right. Number three, failure to warn. If a small child or even an adult uses a product in a normal fashion and there's a chance they can get hurt, there's a duty to warn. And we've all heard about this in regard to Christmas toys and things like that. You have to be able to warn them not to stick the thing in their eye or do anything that can cause, physical damage. In strict liability, the injured person need not prove that the defendant's contact was unreasonable. So in the case with dynamite, if they're dynamiting the quarry next to where you live and one of the beams falls down, cracks you on the head, you don't have to prove reasonability. Under that, there's strict liability, and the injured person does not need to prove that the defendant's conduct was unreasonable. So that pretty much covers it for this particular chapter, chapter 8. What I wanted to do is just kind of give you an overview. They're two fairly simple chapters. Make sure you go through and review them. And then, again, remember, in regard to the project, I'm going to put some topics online either tonight, first thing in the morning, and then I would ask you to start your research. And remember, when you put together your paper, I want to see something that's exemplary of your skills and ability to create a document that could be read in any boardroom in the country. Okay? So with that being said, I am going to click out of here and wish you all blessings. Look forward to talking with you the next time.